All right. So first and foremost, I do have a disclaimer for everybody in attendance today. I am actually not Mitch Kraus. Mitch is our Chief Operating Officer here at Goodwin. I am just commandeering his Zoom account for today's webinar. My name is Cameron Travis, and I am a business development manager with Goodwin out of our Houston operations. And I'm just very excited to be here with you all today and to partner with Adam and bring you guys some great content and hopefully answer any questions that you all may have as you are all graciously volunteering your time and being a leader of your community. For those that don't know Mr. Adam on our call, Adam, do you want to take a chance and introduce yourself here?
Sure. Thank you very much. My name is Adam Pugh. I'm with the law firm of Cagle Pugh. We do a lot of work with Goodwin and Goodwin's clients. My law partner, Greg Cagle, literally wrote the book on Texas HOA law. It is titled, as you might guess, Texas HOA law. So as uncreative as it is, it's a great reference. I know I've looked at it. You all may or may not have a copy. I know all the managers at Goodwin have one, and it's a great reference. And a lot of the information that we'll be discussing today can be found in that book. So if you've got questions on how to get a copy, let us know. But I'm just here to provide some basic information on how to be a good board member. And then, of course, answer your questions. I will tell you sometimes, and I'd hate to say it, but sometimes this material can be a little dry. And the best way we can make it interesting is for you to ask your questions. Go ahead and interrupt me. We've got slides that I can always refer back to, so don't worry about my train of thought. I can always catch back up and get going. So interrupt, ask your questions, tell your stories, and we'll make sure that we are hitting all the hot button issues and answering your questions. But with that, I'll kick it back to you and jump back in when it's my turn.
Awesome. Thanks so much. And again, Adam, thank you for taking time out of your day to work with us here. Great partner, and I really appreciate everything you do with us. I want to take the first few minutes before we let Adam kind of take over here and just go over a couple of things with Goodwin and our operations and those items. The first one, this webinar series, for this Board 101 that we're doing today, we try to do these quarterly. And for those that maybe want to look at some past webinars that we do, as you can kind of see, we have a Facebook and a YouTube page as well, where we go and post all of these, have some great content that we're always trying to push out and keep everybody informed, especially legislative updates as well. So always be on the lookout for those, and these are public, so feel free to share with your other respective board members who maybe didn't have the opportunity to jump on today. Those are out there for you all as an additional resource. Additionally, we're really excited and have really pumped up our blog. For those of you that may not know, if you go to our website, we do have a blog page, and we're really kind of putting some of the hot button items and just general ideas, strategies, and how to be an effective board member, as you can kind of see on the screen. Really quick, easy reads, and these are coming out almost about weekly that we're doing for you all as well. So check those out if you have some time. There's some great content in there for you all. Next, kind of as we transition, just as far as some general and essential resources for Goodwin, our operations, and how we kind of work with you all as board members. Wanted to touch a little bit on this. Most importantly, and first and foremost, Town Square. As you all are probably familiar, is a fantastic way for us to communicate and engage the community and stay on top of our business dealings with you all. Some of the great highlights is where you get your financial reports that are uploaded on the 15th of every month, where your governing documents are going to be housed for your association, where we keep track of those manager assignments and all of the open pending tasks that we're working on for you all as the community is concerned. Absolutely, where your homeowners can go in, submit those requests, and if they have any questions that need some attention from our team, where we can poll the community and gain some further insight as far as if we're looking to make some enhancements to the community and get some further engagement on that front. And then the forum to chat directly with your board and then your other members. Some great tools there that we'll cover a little bit more in detail. Additionally, the board portal through VMS, If you guys maybe do not have access to this, please reach out to your manager directly, or you can ping me in the chat, and we can get you guys set up on that. It's a great way for you guys to log in and pull some live reports. And then lastly on here, we want you to know our leadership team here at Goodwin. So to know your director of community management, or to know Chris Larson, our senior vice president of community operations, and Mitch. So with that, take the opportunity to reach out, send us an email. Love to get to know you and build that relationship with you all a little bit further. Go over these kind of quickly, touching a little bit further on our VMS client portal. VMS, as mentioned, is our back-end accounting software. So you all as board members have and can have a portal to log into this system. In here, and you can kind of see a quick screenshot of about 14 different reports that you can pull at any point in time, whether it be your general ledger, your detail, close of escrow. So great reports that you can pull between our financial reporting periods. You can download those to a PDF or Excel format, and even go in and view detailed homeowner ledgers. So another resource that's available at your fingertips. So if maybe you do not have that, again, reach out to your manager or shoot me a message here in the meeting chat, and we can get that coordinated for you all, but want to make sure that everybody is aware of that for you. Touching a little bit on some communication tools in Town Square, as I kind of referenced earlier, I want to hit a little bit on the assignments. It's a great feature that I know a lot of our communities and many of you are likely utilizing, some maybe not so much. So I want to just bring this up. For us, it's really a huge organizational factor, right? We can put in great details of things that are open for the association, pending tasks, reminders such as, hey, we got a reserve study coming up, or we know every year our insurance is going to renew around the same time. So we can have that set as a recurring basis. Absolutely, as board members, you can assign your managers assignments in here if we need to go in to get bids. It helps keep everything centralized and one place, so where you can kind of get away from some of that email back and forth, or those, where are we at with this standing item. Additionally, one that's also heavily utilized is that board member forum off to the right of the screen here. This is really what we like to do for just open communication, open discussions back and forth, for maybe discussing a pending item and maybe don't need to have it as an official assignment. That's where we can put this confidential correspondence. So if there's something that we needed to consider, or a new board member maybe hops on, they can go into Town Square and then kind of review this and kind of get a bird's eye view of some of the historicals of the association and catch up rather quickly, rather than trying to find a lot of those emails, right? So again, it's a great way to have everything centralized in one spot, for that communication and that seamless transition if there are changes on your board. News and events and website. So with Goodwin, and as you all are probably familiar, we try a two-pronged attempt as far as important communication is concerned. We really want to encourage homeowners, and this is where we definitely like to ask a little bit of support from our board members on, is making sure that we have as many residents signed up for Town Square as possible. So if there is something that is going on, we'll hit that through the news and events, so everybody stays up to date with what's going on there. Especially also, this is where we go ahead and post our board meeting notices and those announcements and the agendas for those board meetings. So news and events is great just to kind of keep everybody engaged. And many of you are likely aware, but some of you may not, but Town Square actually and also hosts a website for your community. So through here, to access this, you can just go to goodwintx.com through our Goodwin website. On the top right, you can kind of search to your community name. Once you click on that, it'll bring this pop-up window that goes directly to your website. In here is a bunch of great public resources, such as just your general association documents that you can find, and then a lot of frequently asked questions for your community. This is something that your manager puts together and is going to update on a frequent basis, as far as just the most common questions of what do homeowners maybe need is, hey, when is trash day, or how do I get a key fob for the pool, right? So there's a lot of great information in there through that website. In addition to that, we can also go and get a custom domain for you all. So it could be easier searchable for your homeowner. So terravista.com, right? As we can kind of see, we can do that. So if any of you are interested in maybe getting a custom domain registration for your community, let us know or reach out to your manager, and we can definitely start those efforts and do that. And it's a relatively low cost and a great feature a lot of communities are jumping on board with. As kind of mentioned, surveys, just another way that you can get input from your community members. It's helpful when making a big decision, and can, if the board is maybe also split on a decision, to kind of pull the community and maybe have that be your sway factor, if you will. So something it's free, it's out there, it's included. So utilize when we have something like that comes out. And then, as I mentioned, documents as well, where historical information, your financials, your governing docs will all be housed in your platform for you. Lastly, on Town Square, ACC features. I know many of you probably are already signed up and utilizing the ACC feature in Town Square. If not, and are interested to learn more, let us know. We're more than happy to kind of go over a demo with you all. It is a wonderful feature, and it's seamless for homeowners to be able to go in, submit that project, upload those documents, the plats or the surveys that they need for whatever it is that they're looking at doing, and to stay in tune, right? Many times that we receive questions or things from homeowners where, hey, we don't know what the status is of our ACC application, or where are we at with the committee? It's been 6 days, right? So you probably might be aware that once this goes from submission to open to vote, your homeowner will get pinged through Town Square to say, hey, look, your project is open to vote. It's in the voting process. We've been approved. Here's your instant verdict letter, right? It's wonderful, and it's extremely customizable. So if we have different projects, whether it's from a fence or a roof replacement, we can make that set up to where we have those preset colors or those samples in there for you all. Again, Town Square is great, and just wanted to highlight a few of those features. If anybody has further questions or like some detailed demos, please reach out to your manager, and we can get that coordinated with you all. As we kind of transition here, this is one of the things that we always like to bring up, and this is where a table that we got from the CI board member toolkit. If some of you maybe aren't familiar with that toolkit, we'll be more than happy to shoot that over to you all, so let us know. But what are the qualities of a good board member? And want to discuss this because oftentimes we're dealing, and as you all are dealing with other members, if you're dealing with 3, 5, 7 board members, right? There are sometimes difference of opinions and some items that come up on that side. So just kind of quickly hit some of the characteristics to kind of keep in mind of a strong board member. One of good character, strong integrity, calm judgment, a willingness to serve, commitment to the best interest of the community as a whole, relevant experience or background, previous volunteer experience, and strong people skills. Sometimes we do find that board members maybe jump on for personal reasons, and those are going to be ones or of qualities of an inappropriate board member, right? Unable to put the welfare of the community first, works behind the board to run things his or her own way, impulsive or quick-tempered, has a personal hidden agenda, puts individual interests first, unable to work with others, or poor interpersonal skills. Just want to always throw this out there, and for some of you probably new board members as well, and jumping into the seat just to kind of think and reflect on some of these qualities. And at the end of the day, we understand, and you all probably do as well, that there's going to be some difference of opinions, right? I know there's going to be times where you might feel really strongly on an issue, and that vote goes your way, or sometimes it might not go your way. To always reflect and think about the betterment of the community as a whole, and make sure we have that in our minds, and not that we're focusing on a narrowly tailored issue that's going to serve the interest of a personal need. So always want to just kind of touch on that, and just as a reminder, throw that out there. And then go quickly over the role of board members and management. I know Adam's going to talk a little bit further about this, but from our side as a management firm, partnering with you all, right, in a typical sense, and I like to say a typical sense because we understand that some communities take on different structures that fit their own individual and unique needs, and that's absolutely okay. But typically, these are the general roles of board members in your community, right? The president is there to kind of oversee those operations. They speak for the board and the association, engage others to move association business forward, right? So they're kind of steering the ship and the ones, the full range of everything going on. Vice president, substitute for the president in their absence, and generally the one that might be the one coordinating and steering all of the committees as well. So being the forefront of that, making sure those committees are on point and focused with those tasks at hand and working for the board. Secretary, official bookkeeper of the association's records, right? Making sure that everything's documented properly. We're following our CCNRs and those items. And then, of course, your treasurer, he's your CFO of the association, or he or she, excuse me, making sure the finances, all of those things are taken care of. One thing I always like to point out too is that the difference between a resident and a president, it's a P, right? It's simply a P. It's one letter. So though we have titles and we have these general roles and duties, let's not lose sight of the fact that we're all residents at the end of the day, all volunteering our time for the betterment of the community. So as we work together as a board, and as all of you have shown that you are here to do the right thing and being a part of this webinar today, sometimes it's not focused so much on the titles, but make sure that we're looking at delegating tasks and working to the benefits of the backgrounds that you bring. So if we need help and want to move through some of those items, again, to reach out to manager or myself, and we can kind of coordinate and dive deeper to that to kind of organize the board. But again, at the end of the day, we're all residents and we're all members and all have the same goal in mind. With that, as far as the role of management and how that plays with the board and you all, our role is to help kind of coordinate, supervise maintenance activities, alert the board when legal assistance is needed, coordinate member communication, manage association finances, and take care of that accounting aspect. We're going to be there to provide oversight, coordination of vendors, and to work with those professionals to get the job done for you all. And then manage compliance with respect to your governing documents, making sure those items are taken care of. At the end of the day, we take direction from you, all the board members, and act on behalf of your guys' direction. So the question then poses is, how does that work between the manager and the board? So the board is responsible to make those decisions and set that policy. Management then goes and we're going to go implement those directives. The board makes sure that we have a consensus on that policy and direction. So we know that, hey, we're moving forward in the right sense here. We're going to go work with the board president to fill that policy, and we're going to serve at the pleasure of you all, right? So though we work at your guys' direction, we want to make sure that this is an open partnership, and we're all on the same page with the communication and the direction that we're trying to take as a community. Lastly, real quick, financial management from Goodwin's aspect. Again, these are uploaded monthly to Town Square in those document sections, as previously mentioned, on the 15th of every month. Don't forget, you have those live reporting available in VMS. Our financial package consists of that financial statement, AP, AR, general ledger, and that bank reconciliation. As you guys know, we do send out these quarterly board member updates and upcoming webinars and other things, so make sure you keep your eye out for those. And then I know it seems crazy, but we're already here middle of May. We will kind of start that budget process here in the next couple of months. So just kind of keep that on the back of your guys' mind for some of you that have those budget committees. We are rapidly approaching that time to start planning already for next year. So thank you all for bearing with me with that part. Again, just wanted to kind of touch base on some of our essential resources at Goodwin and touch on some of those overarching resources available to you all. But at this point, I believe we are ready to turn this over to Mr. Adam and let him get going on his side.
Well, thank you very much. I appreciate it. And I just want to tell everybody on this call, first and foremost, thank you so much for being involved with your board of directors. I know that none of you are paid to do this. You're all volunteering your time. And now you've gone out of your way to take some more time to try to get good at it as well. And that's certainly very much appreciated. As we go through this, I think the overarching theme that I'll try to convey is that you are expected to be volunteers. You're expected to not get paid. You're expected to be donating your time, and because of that, you're not going to be held to some standard of being a lawyer or knowing every single statute or law or regulation, and understanding that's always going to be a challenge to learn all of that. The guiding principle that you should follow is just to be reasonable. Put yourself in the shoes of the owners that you deal with, and imagine how you would want to be treated. And most of the time, as long as you're being reasonable, things are going to work out pretty well. So if we can go ahead and skip through to the next, there we are. I always like to start out with a little cartoon. I think this one really illustrates some of the issues that we have. The board is sitting together and someone says, what if we don't change at all and something magical just happens? I think it illustrates the idea that if you want to improve your community, if you want to do things the right way, you've got to put some effort into it. And that's a lot what we'll be talking about today. So we can go ahead and scoot to the next one. Now, almost all Texas community associations are going to be managed by a board of directors. The board of directors is generally responsible for setting the goals, standards, and policies of the association, enforcing the governing documents, maintaining the common areas, and entering into contracts for services on behalf of the community. Certainly, there are other things that you do, but these are really the foremost duties of the association. And those are the job of the board of directors. In order to carry out these roles and responsibilities, there are the 6 C's of community associations we'll talk about today. That's contract, corporation, compliance, collections, covenants, and community. And so we'll go to the first C, which is contract. And a community association is simply a private organization that is established by a written contract. We usually refer to that contract as the declaration. Sometimes you'll hear people call those the CCRs, but in general, this is just the document that gets filed in the official public records for your county and sets forth all of the covenants, which we say run with the land. That just means that regardless of whether you sign a piece of paper or even read the documents, you're bound by them by virtue of your ownership. The association is made up of property owners in what's referred to as a common interest development. So that's either a single family residential association or a condominium. These are all common interest developments, and for the most part are very, very similar. The association will be vested with the management and the maintenance of the community, and its amenities are commonly owned property. Go to the next slide, please. The declaration is recorded by the developer in the official public records where the community is located, and it runs with the land. It's a private contractual agreement that imposes obligations on the owners of the property that are subject to the declaration. Both the association and the owners are equally bound by the declaration, and anyone that violates it can be sued for a breach of contract. There are 3 categories of contractual obligations. First of all, you've got mandatory membership in the association. So if you are here today as a member of your board of directors, those that own property in your community are members by default. You also are going to have the obligation to pay assessments that are levied by the association and the obligation to comply with the restrictive covenants. Also, we call those land use restrictions. And those are the 3 primary obligations. The declaration is the most important of the community association's governing documents. It will generally trump any conflicting provisions in the other governing documents, aside and apart from the certificate of formation for the association but very, very rarely will that come into play. All right, so that concludes the contract portion. Now we move to corporation. Almost all community associations are going to be incorporated as Texas nonprofit corporations. Prior to 1994, there were multiple condominium associations which were unincorporated. If you have one of these associations, your declaration will refer to the governing body of the association as generally the council of co-owners. You'll also know if you're in one of these associations because your home won't be referred to as a unit, but it'll be referred to as an apartment. This is becoming less and less common. Even those associations are starting to incorporate because you do enjoy some benefits when you do that. A Texas nonprofit corporation will be governed by its corporate governing documents. These consist of the certificate of formation, used to be called the Articles of Incorporation. But when the Texas Business Organizations Code was codified back in the early 2000s, we changed some of the nomenclature. And then, of course, the bylaws. A lot of times we hear folks using bylaws and declaration or CCRs interchangeably. These are two different documents. You're not going to get in trouble if you get them confused. But when you're talking about the declaration, it's important to refer to that document as being as separate and apart from the bylaws. The biggest difference is the bylaws really talk about how you internally govern your association, how you elect officers and directors, how you remove them. And then the declaration will talk about everything else, like use restrictions, assessments, how they're assessed, if you can foreclose, if you can issue fines, how you enforce the restrictive covenants, and those types of things. So they are two different documents. The certificate of formation, I like to say this is basically the birth certificate for your association. It's going to have your legal name, the purpose which it is formed for, and whether or not it's going to be managed by a board of directors or its members. If you're here, yours is managed by a board of directors, but I would make sure that your certificate of formation indicates that. Every once in a while, these get filed by someone who might not be as well versed in these issues as you would hope, and they might check the wrong box. These are all fixable issues, but I would take a peek at your certificate of formation if you're on the board of directors just to confirm everything matches up with what you think it should be. The bylaws will generally provide procedures for how many directors and officers there are, the election and removal of directors and officers, where to have meetings, both regular and board meetings, where and when to have annual and special membership meetings, and procedures for amending the bylaws. The thing that I would also encourage you to do is check your bylaws and make sure they match up with the number of directors and officers you presently have. I can't tell you how many times folks have come to me and said, well, we have 9 directors, but that's not what our bylaws say. Well, then you've got the wrong number of directors. And these are all issues that can be fixed, but the number of directors and officers you actually have should line up with the number that you should have. So that should cover the bylaws. Moving on to compliance. Compliance really refers to the association being in compliance with its declaration, its governing documents, and applicable statutory laws. That makes up the majority of what I do all day long, is making sure that board members are making choices that keep their association in compliance with these specific obligations. Chapter 209 applies only to subdivision associations. It's known as the Texas Residential Property Owners Protection Act. It is a regulatory statute, which means that when you are looking at Chapter 209, it tells you the things that you cannot do as a homeowners association. It limits what an association can do regardless of what your declaration or your other governing documents can do. This is the opposite of statutes like Chapter 81 and 82 that apply only to condominiums. The Condominium Association or the Condominium Act will actually authorize condominium associations to have certain powers, even if their declaration or bylaws don't contain them. So it's a little bit different when you're looking at Chapter 209 versus 82. Chapter 209 will trump conflicting provisions in your declaration and governing documents. So just because you find something in your declaration or your bylaws, make sure it's also allowed by Chapter 209 of the Texas Property Code if you are a subdivision association. Getting back to the Texas Uniform Condominium Act, this is Chapter 81 and 82. Chapter 81 will apply only to condominiums that were organized prior to January 1st, 1994. And then Chapter 82 will apply to condominiums organized after that date. In addition, there are certain sections of 82, and I believe you can go to 82002, and it will tell you the provisions of Chapter 82 that also apply to the pre-1994 condominiums. As I mentioned before, this is an empowerment statute. It grants you certain rights, like the ability to fine owners for violations of your governing documents. This is very different from Chapter 209. In a subdivision association, you may not fine owners for violating restrictive covenants unless your declaration expressly says you've got the power to fine. In a condominium, your declaration can be silent on fines, and you can still fine owners based on Chapter 82. There are very few regulatory provisions in 82. It provides some guidelines, but really no prohibitions. You also need to stay in compliance with Texas nonprofit corporation law. Specifically, we're talking about Chapter 22 of the Business Organizations Code. It applies to all community associations that are incorporated as nonprofit associations. It's a gap filler statute, which means that it provides default rules in the event your governing documents don't address specific issues. We can go to Chapter 22 when our bylaws are either confusing or simply lack provisions related to something we're trying to do. So it's important that you stay in compliance with the organization's code. Moving to collections. Collections is one of the most sensitive topics that we deal with for homeowners associations. Collections is something that you've got to take seriously. The assessments really are the lifeblood of your association. There's only three things that you really do. You collect assessments, you manage the common elements, and you enforce the deed restrictions. And you can't do either of the last two things if you don't do the first thing and collect assessments. Almost all associations are going to be able to levy assessments on their members, and the authority to levy assessments has to be established either by statute or in the declaration. If you're here today, though, it means you're paying a management company. If you're able to afford to pay a management company, you're collecting assessments. Now, the declaration is generally going to establish the types and procedures for levying assessments. It's going to provide the obligation to pay assessments is a personal obligation, and it's also going to establish a lien in favor of the association to secure the payment for assessments. For condos, a lien is established by Chapter 82 of the Property Code. But if you charge regular assessments, you're going to have the ability to lien. Otherwise, it's going to be very difficult to collect them. When property owners fail to pay assessments, the association must generally engage in collection efforts. This can include sending demand letters from the association or its managing agent, recording notices like notices of lien affidavits in the official public records, and then, of course, foreclosing on the lien. Collection actions by a community association are governed by the declaration, the Texas Debt Collection Practices Act, and the Texas Property Code. There's also a Federal Debt Collection Practices Act and Regulation F that has been put out recently by the Consumer Protection Board federally. So there are a number of issues to deal with when you're collecting assessments. It's kind of a complicated playing field, and I wouldn't encourage individual board members to undertake the collection of these assessments on your own. I know that sometimes it would seem very neighborly to go knock on people's door, remind them that they owe some assessments and they should write a check. I would simply discourage you from doing that, because if you do that and you don't do it the proper way, you could have violated all of the laws that I just mentioned, including your own declaration and bylaws. Now, collection actions by an association can also be affected by the homestead of an owner, whether or not the owner is on active military status, and if the owner files bankruptcy. So these are all issues that whoever is collecting assessments on your behalf should be well versed in.
Great. And Adam, I got a question for you as we're kind of talking on
Sure.
collections. Something I've gotten a couple of times here recently, but generally, I guess for associations that are a little bit older, right, they might not have a late fee written in their CCNRs as far as if the homeowner is late on their assessments, or maybe they're at maybe a 10% interest if they're late rather than the now current 18%. Is there anything that you can do outside of having to amend the CCNRs to change that, or what recommendations would you have for some of those?
Well, typically, no. I mean, if the declaration does not authorize a late charge or a specific interest charge, then you're probably stuck filing a lien and pursuing foreclosure. We can sometimes find provisions that allow for some type of a late fee or a penalty for paying late. But if it's not expressed in your declaration, it's going to be tough to do any of that without a declaration amendment. And passing declaration amendments, and getting 2/3 of the community to vote to charge themselves a late fee is pretty tough. It would be like if the federal government had an election to raise taxes. We probably know how that would go.
Yeah, absolutely.
But we can always take a look, and there can be certain tactics that we can use. We can certainly send demand letters that emphasize and expressly state what the cost is going to be if the matter gets to our office, and how that can rise substantially. I would also say that while we talk about foreclosure and foreclosing liens, our office handles thousands of these matters every year. And certainly foreclosure is a powerful and serious tool, and we threaten it quite often. But in reality, we don't have to use it very often. We certainly file lawsuits asking for foreclosure. We go and take default judgments that authorize foreclosure. And then we do everything we possibly can to avoid foreclosure by sending multiple notices to owners, giving them payment plans, everything that our office does in the collection process. And I know everything that Goodwin does as well is to get the owner's attention. So they call us, they talk to us about their particular needs and their situation. We craft a customized payment plan for them and then get them back on track so that the association can get its much needed assessments paid and the owners don't end up losing their home over a $2,000, $3,000, $4,000 debt. So we work with these folks on a daily basis to come up with things that are affordable. If they can afford the house, they can afford our payment plan. We'll make sure that. And we'll get owners back on track.
No, that's great. Thank you. Guess moving on, huh?
Yeah, moving on to covenants. This C relates to covenants which regulate the use of a lot or the unit by its owner. The covenants are intended to preserve and protect property values in the community and the owner's peaceful enjoyment of their property. They can generally be described as either mandatory covenants, so these are covenants that impose an obligation for you to do something, like maintain landscaping or keep your property in a aesthetically pleasing manner. And then there's prohibitory covenants, which impose an obligation to refrain from doing something, like parking a boat in a driveway or painting your front door pink without approval from the association. Enforcement of covenants can be by both non-judicial and judicial procedures. Non-judicial procedures have to be authorized by the declaration. Those are things like self-help remedies, and as we discussed, the assessment of fines. Self-help remedies, usually we refer to those as a force mow. You've probably heard that term, but there are other self-help remedies like removing junk from somebody's front or backyard, or bringing a property into compliance with the association's governing documents and then charging the owner for that. There are usually some pretty substantial notice requirements that you've got to give before you undertake self-help remedies. And even if your documents don't require them, I always encourage that. We live in Texas. We're a pretty heavily property rights favoring state. Before you go onto somebody's property and start messing with it, I encourage you to give them lots of notice. But that's not to shy away from these remedies. It's just to encourage everyone. Again, like I said, let's be reasonable. Let's treat neighbors the way that we would want to be treated ourselves. But once you've sent somebody 2 or 3 letters about, removing the washing machine from the front yard, and they don't do it, well, it's time to send over junk busters and haul it away. And usually that's the easiest way to solve the problem. Now, judicial enforcement consists generally of filing a lawsuit against the offending property owner for breach of their duties, and then seeking either specific performance or some type of an injunction, which is simply an order from a court that requires the owner to bring their property into compliance with the governing documents, or they face the wrath of the court and being in contempt of court. These are usually very serious issues, and we aren't suing people to get injunctions because they haven't mowed their yard in a month. We're usually talking about bringing property into compliance where you've got a burned down building that's been there for 3 years, or you've got a semi truck parked in somebody's front yard. Certainly there are other examples I could think of that might not be quite as serious that would involve the filing of a lawsuit, but they are usually non-standard issues. These are not, your dog barks too much, or you need to mow your yard kind of things. It's also judicial enforcement. It's important to remember is subject to affirmative defenses. You've got the statute of limitations. So one of the things that I always find to be a very positive aspect of a new board is a new board comes in, they take over, they want to do the right thing, they start looking at the restrictive covenants, and they realize that the old board simply wasn't enforcing the deed restrictions the way that they should have. And so they want to kick that into gear, and for whatever reason, it's usually sheds that come up. So I get a lot of calls, hey, we've got a prohibition against sheds, and in our 300 home community, we've got 16 sheds, and they weren't approved, and we need to do something about it. Well, if those sheds have been there for 4 more years, there's probably nothing you can do about it. And importantly, you may have waived the right to enforce those because you've let so many people violate the covenants for so long. When you do decide to start cleaning house as the new board, be sure that you are taking into account the statute of limitations. The other affirmative defenses, abandonment and waiver, are similar to selective enforcement. These are basically defenses saying, well, you let other people get away with this exact same violation. And if you've got more than about 10% of the community violating a particular covenant without enforcement, you've probably waived that covenant. So that's a good rule of thumb to keep in mind.
Perfect. And a question on that one, on the statute of limitations, right? New board comes in as you're speaking to and going after the sheds, if you will. How do we know, or what's the recommendation to approve the statute of limitations, or is that on the onus of the homeowner or the board to be able to prove that?
Well, before you file a lawsuit or engage our law firm to go and enforce the deed restrictions, you need to do as much research as you can to find out, well, how long has this thing been there? And again, there is some reasonableness that gets built into this. If you've just discovered the violation because it's behind a fence or otherwise, hidden from view, and the only reason you found it is because the board member was on the walking trail behind the house and stopped to tie their shoe and look through the wrought iron fence. I mean, these are all things that can come into play. And the discovery rule can apply, which simply means that the statute of limitations is told during a period of time when the association wouldn't have had any idea that the violation existed. Of course, if you can't see the violation from the street, I might have some questions about why we care. But you know, it's important to try your best to figure out how long a violation has been in place. But certainly it will be the owner's obligation to raise the statute of limitations as an affirmative defense. But it's the board's obligation not to file frivolous lawsuits. So if we have information to suggest a shed's been there for 15 years, we probably shouldn't go and sue somebody to remove it.
No, that's fair. That's really helpful. Thank you.
Now, both non-judicial and judicial enforcement procedures are subject to due process requirements before the association can assess a fine, charge an owner for damages they caused to the common areas, file a judicial enforcement lawsuit, that applies to subdivision communities only, or suspend an owner's right to use a common area. In each of those instances, you've got to give somebody the ability to cure the violation and a right to a hearing if they request one. Finally, the final C is community. As a board member, you are the ambassador to the community. The community association combines the characteristics of a local government, a business, and a community. And it is a strong sense of community among the residents, and clear lines of communication are essential to creating a community spirit, encouraging active participation by residents, and building a vibrant, responsive, and healthy community. I would simply tell you that transparency is the key to preventing a lot of the disputes that I see. A lot of times folks have access to the information on your website, but they just don't know where to look or don't bother to look. And I would simply encourage the board of directors not to hide behind the management company or the website, or avoid communicating with owners. Owners are going to have questions, and as long as they're being respectful and trying to reach out for legitimate concerns, I would do my best to provide them with the information they ask for in a very efficient way. The thing that I see causing the most trouble are when board members refuse to answer questions or want to operate in secret or don't want to involve community members in decision making. The more transparent you can be, the less problems you're going to have. But that's probably the best advice I can give you. Board members should always promote a high level of community involvement in terms of voting, attendance, and volunteerism. You're volunteering your time. If you give people the opportunity, though, to volunteer theirs and to serve on committees, then you will be surprised by how often you can get those volunteers. People want to contribute. They just need to know how to do it. Promote transparency in the operation of the association. Post your budget. Post what you're spending your money on. If you're trying to gauge the association or the community's opinion on something, have polls. Issue polls and find out what the community wants, and solicit their involvement, and promote resolution of disputes and issues in a neighborly manner. All of these will go a long way in fostering a sense of community and a peaceful time with your service on the board. All right, well, there's my contact information. I always encourage board members to reach out. If you need anything, jot that down. I'm sure your managers all have that information, hopefully stored in their cell phones. But if you ever need anything, have a quick question, I always encourage you to let me know. I don't start the clock running on billing you just because you've emailed or called me. I'll always let you know if your question is going to take a bunch of time. I've been doing this for 18 years now, and almost always I've heard your question before, and I can direct you to an answer in 5 or 10 minutes. If that's the case, you're not going to see a bill for that. And I'd much rather encourage you to ask your questions and get some advice before you get yourself into trouble. I've got plenty of work to do with litigation from folks that didn't ask me questions before they made decisions. So I'd much prefer to help you out and get you the advice you need.
Perfect. And again, Adam, thank you so much. I did receive a couple of questions from when some members did register, so I'm going to pull that up on another screen here. And to everybody else still on the call, guys, this is your time. If you have any questions for Adam while we have him, again, free legal advice and counsel right now of any issues that are going on within your current community or about anything that we discussed today, please feel free. You can unmute yourself or just send a quick message in the chat. We have some time left. Let's go ahead and answer some of those specific questions that you all likely may have. As I monitor chat, or if anybody wants to chime in here, please feel free to do so. But I do have a couple that I will. Go ahead, sir.
Question.
Yes, sir.
Question is that sometimes we reach out and get legal advice, and I don't know if it's the property manager just doesn't ask the questions that are appropriate, because some of the answers we get back, I'm just thinking to myself, let me talk to the lawyer. Is there a direct path to talking to lawyers?
It's up on the screen. There's my email address and my phone number. That
All right.
rings at my desk for just like my phone's ringing right now. And I encourage you to use it.
Excellent. I think that will answer my questions. Thank you.
Absolutely. And Robert, as kind of mentioned earlier, we work at the board's direction, right? So if that's something that you all as a board or a board member want to take over and have that direct communication, absolutely. I guess what we would ask from Goodwin's side is just to have that communication with your property manager, so we're in tune and on the same page. So we're not double dipping or doubling any efforts on that front. But of course, it's your community, it's your question. Have that direct contact. As I look through this, and bear with me one second, there's a couple of screens up. And Adam, I think we touched on this a little bit here, but what role does a mortgage play in addressing delinquent accounts and any obstacles that the mortgage on the home creates as we're trying to go after past due assessments?
Not really. When we do, I'll put it this way. So the lien the association has for its assessments is junior to a first mortgage lien generally. What that means is that when we go to foreclose, we are foreclosing subject to the first mortgage. That means that the purchaser at the auction doesn't have to pay off the first mortgage, neither does the association. And it really doesn't cause us any problems. So for instance, if we really did get all the way down to a foreclosure, we go down to the courthouse steps on the first Tuesday of the month and auction off the property, we only have to collect what's owed to the association, and then the buyer at the auction takes it subject to the first mortgage. And so that new owner might be on the hook for the mortgage, but the association isn't. So the short answer is it doesn't cause us any problems at all.
Perfect. Okay. These next two are a little bit the same regarding financial management and oversight. What are the true obligations of the board with respect to financial management, and are financial audits required for us to conduct every year by a third party?
So I'll take the second question first. If you are a condominium association, Chapter 82 of the Property Code requires an audit every year. If you are not a condominium association, then you are not subject to that same requirement. The obligations of the board of directors with respect to financial issues is a fiduciary duty. So in other words, you've got a duty that is over and above your own self-interest in managing the association's finances. So you have to make reasonable decisions. You are protected by the business judgment rule. There's also some other protections for board members, but you have to be reasonable. If you are spending a substantial amount of money, you've got to go and get bids. In Chapter 209, a couple of years ago, the legislature passed a rule that basically said you need to have a bidding process in place if you're going to spend more than $50,000. And I think that's a good rule. You've got to treat this like a business and run it the right way. And you've got a duty to the other members of the association to spend their money in a reasonable fashion. It's a little more, it can get a little bit more complicated than that. But I think that's a good rule of thumb as you guide your association and make those financial decisions. And you've got a manager that is well versed in these areas. So choosing vendors, finding out if something's a reasonable price. These are things your management company is going to be great at doing and really good at helping you with.
Perfect. I think that's great. Next one is any advice for a project the associate needs to implement that's going to require a special assessment? How do we go about getting that approved, or what course of action do we need to take?
Well, it depends. Certain amounts and certain associations require various approval by the members of the association. And so if you do need the approval of the members in order to issue a special assessment, they're going to want lots of information. And if the project is significant enough to where you need to issue a special assessment, that tells me go and get at least 3 bids. Have plenty of information on the vendors. If you've got a vendor in mind that you think is best, go ahead and let the members know about that. Educate the members on the information that you think was important and the information you got in that regard, and then push forward with the special assessment, getting the approval you need. If you don't need the members' approval in order to issue a special assessment, I'd do all the same stuff I just said, especially when you're wielding that much power to issue a significant additional assessment to what folks might be budgeting for. They're going to want lots of information about why am I writing this check, the same way you would if you were being told to write the check. So I'd have all the same information. I'd be able to show them that you got the bids. I'd make the bids available online to the extent they don't have to be confidential from the vendors, and educate the community on why you're having to do what you're having to do, and by all means give them as much lead time as possible. If you know about a special assessment but it's not going to be charged for 9 months, tell people now. Tell people now, even if you don't have a firm bid. If you think it's going to be, the total cost is going to be between $50,000 and $100,000, tell them what it is. Tell them why you don't have the exact figures and what information you're going to seek in order to get that information for them. Again, transparency is key to these types of decisions, and the thing that's going to keep people from, sharpening the pitchforks and lighting the torches and coming to the next board meeting to let you know how upset they are with you. People can take bad news, but they really have a fear of the dark.
Right. No, I think you hit it with the transparency part, right? As far as just providing as much information as possible and just being honest with everybody. At the end of the day, we're all members, all bought into the same property. So just taking it with that. The other one that we've seen a lot as well is maybe offering a payment plan too. As far as that special estimate is concerned, maybe breaking it into 2 or 3 payments over maybe a 6-month period, just to give a little bit more of a break, as we're in an economy with rising inflation, and we understand that times are tough. So that's another option to consider as far as maybe breaking that up a little bit.
Mitch, can I ask Mitch? I got a question that kind of goes in line with this. Adam, if we've got a large infrastructure that we know we are going to have next year, when we start talking about the budget aspect, I mean, would that be considered part of our budget, or would it be considered part of an assessment?
It depends. Yeah, no, it's a great question. We get this all the time. I mean, sometimes you will have, there'll be a dichotomy in your declaration between normal operating expenses and capital improvements. And so if you're making capital improvements and your declaration calls out a difference between those things, then yeah, you'll probably have to explain to folks why you need these capital improvements. If these are just repairs, though, because you've got either an aging community or simply have to make repairs to infrastructure, that's probably not a capital improvement. unless you're, substantially changing what's already there. But this will be governed by your declaration specifically. And one of the other things that I would recommend, certainly for condominium associations, if you haven't had a reserve study done in the last, I'd say at least 5 years, I would highly recommend you get a reserve study done. But I recommend that for subdivision associations as well. Subdivision associations vary greatly in the common areas and common amenities. If you have millions of dollars worth of real estate and playgrounds and parks, get a reserve study done. In my neighborhood, we have 2 rock monuments and 9 landscape lights. Probably don't need a reserve study in ours. So use your best judgment on that. If it's very easy to know what kind of reserves you need based on very limited assets, you probably don't need a full-blown reserve study. But if you've got anything significant, I would get that done. The reserve study will tell you how to set your assessments. These are experts that do these types of calculations on a daily basis. And anytime you can defer your authority to an expert and get an expert opinion, I recommend doing that. That I think certainly discharges your fiduciary duty to the other members of the association when you rely on an expert and not just your own, back of a napkin guesswork.
Okay, thank you. And then just a follow-up question. Is there any real difference in terms of the laws that are applicable between a property owners association and a homeowners association? And in our particular case, we have what we're talking about for infrastructure is a 260 acre lake.
Yeah, so I get that all the time. People say, well, we're not a homeowners association, we're a property owners association. There's no difference. There are 2 kinds of property owners associations in Texas: condos and everything else. And I also get the question, well, what? No, we're actually we're a garden home community, so that's different. Or we're something else. These are all marketing terms. You're either a condominium association governed by Chapter 81 or 82 of the Property Code, or you're a subdivision association governed by Chapter 209. There aren't other categories. I'm always happy to help you figure out which one you are, but there are no in-betweens.
Okay, thank you.
Of course.
Absolutely, great question, Jeff. Next one, what sort of increase can be taken on the monthly assessments if the HOA is cash poor and can barely cover operating expenses?
That is 100% going to be based on your declaration. Your declaration will set forth the limitations on your ability to raise dues. Most commonly, though, dues are set by the board annually by adopting a budget. Now, that doesn't mean that you can only change the dues once a year. There are usually provisions that allow you to amend the budget midway through the year. So it's generally budget driven. And what you need to do is focus on what your budget is. How did your budget change? Amend your budget, and therefore you can amend your assessments. But that's a very general question or a very general answer to your specific question about your association. And the real answer is we'd have to take a look at the declaration, which, I'd be happy to do if that's not a hypothetical, but something you're addressing right now. I'd be happy to take a look at your declaration and give you a straight answer.
Perfect, thank you. I got 2 more here. Requirements for meetings and what activities should or should not happen in open board meetings or workshop meetings.
Okay, so I think I know what you're getting at here. First and foremost, in open board meetings, you need to stick to whatever's on the agenda. I know there's a push to be kind of generic on the agenda, have an item called new business and let that cover everything. I'd try to be more specific than that if you can be. If you're just making little decisions about, well, are we going to have the landscaper do mulch in April, or are we going to wait till May this year? Or, what time should we open the pool this summer? Should we open it at 8 or wait till the lifeguards get there at 9? That's fine. That sounds like new business to me. If you're approving $1 million contract to install playground equipment, I'd put that on the agenda. Again, just be reasonable. New business can cover the minor stuff, but major things should be reflected on the agenda, and you should stick to it. With respect to workshops, I get this question all the time. About 10 years ago, the legislature came in and made a pretty big overhaul to the statutes that affect homeowners associations. And there's a specific provision in there that required open board meetings and a prohibition against secret board meetings or having meetings where you made decisions outside the presence of the owners. And so there was this idea that, well, the board can never get together in anything other than an open board meeting, and folks tried to kind of apply governmental regulations on open board meetings to homeowners associations, which is just not appropriate. So board members can get together, they can do workshops, you can talk about how we're going to have the annual meeting, as long as you're not voting. As long as you're not voting on something that requires a board meeting and an open vote, then you can get together, you can have dinner together, you can have happy hour, you can have these work sessions, you can do all of these things without fear that you're violating your fiduciary duty to the association. So there's no real hard and fast rule about what can we do and what can't we do other than voting. You can't vote at a workshop. You can do anything else you want.
Perfect. Thank you for that. The last one I believe I have here, how do we address speeding in our subdivision? What authority do we have, if any? And I would guess that this might be public single family and maybe not a gated community, but not 100% certain.
Yeah, moving violations are tough. I mean, you're a homeowners association. You do three things. You collect assessments, you maintain the common elements, and you enforce the deed restrictions. But that doesn't mean that you're going to be very good at enforcing speeding. There's a lot of things you can't do. And getting out there with the radar gun and issuing citations for folks that speed is going to be tough. Now, it is a serious problem, and we most of us move in neighborhoods. We have kids, or we want to raise a family. We want them to be safe. So I'm not suggesting it's not a serious issue. It's just not one that's really within the purview of a homeowners association to address. You don't have a police force. You don't have an investigation committee. You don't have an ability to enforce these kinds of things. So I would just encourage you to cooperate with local law enforcement. I know, for instance, in my neighborhood, we've got a great relationship with the local constables. Constables are pretty good at coming out and setting up speed traps when you request them to. Now, they might not get out there the same day, but they might be out there in 6 weeks. And having a constable come and set up a speed trap once every few months sometimes is enough to discourage people from speeding. They see a few people get pulled over. They're reminded of that every time they pass through the neighborhood. I would make sure, or I would try that. And if that doesn't work, sometimes there are partnerships you can do with local communities to install those, the speed monitoring signs. Sometimes you can get one of those put in. And it also depends on if you own the streets. If you do own the streets, it doesn't make enforcement any easier. It just makes it more legally possible. So, that's a tough one, and one that I think we all are challenged by. Let's see. Kay asked a question here in the chat. She said, "How do you handle or resolve complaints of a sensitive nature? Is the answer made public? Is the discussion private between the board?" Well, this is an issue I get all the time. People will want to make complaints about their neighbors anonymously, and that just doesn't really work very well, especially if we're going to go judicially enforce an issue. And so, if we don't have a photograph that we can use, if we don't have a recording of a violation, if we don't have evidence, it makes it very difficult to enforce restrictive covenants against an owner based on an anonymous complaint. So I understand wanting to preserve the privacy of the complaining owner, but it's very hard to give due process to the other owner if they can't be confronted by their accuser and find out who the witness is that is accusing them of violating the restrictive covenant. So it's a tough position to put the board in. You know, you want to enforce the rules equally. You want to afford everybody privacy and their own rights, but it's very difficult to follow through with a particular complaint if you can't use the folks' name that are making the complaint. So, you know, I handle these on kind of a case-by-case basis. I'll usually reach out to the complaining owner and explain this to them, let them know, look, I understand why you'd want to remain anonymous, but you know, if I'm going to take this on behalf of the association, then I'm going to need you to cooperate and be a part of the process. And if you can't do that, then we probably can't file the lawsuit. You know, the owner that the complaint is against does have rights as well. And certainly if information is being requested about individual violation histories or delinquencies, then you know the association has the right to keep that stuff private. I hope that answers the question, but I mean these are the toughest issues that you face, and you know you have to try to account for all of the rights of all of the people involved, and it's not always an easy task. And so these are the ones where there isn't a hard and fast general rule that I can give you. These are the ones that you're going to need to probably engage, you know, us or another law firm to help you with.
Awesome. Thank you so much. Those were the rest of the questions that I had that were submitted from the registration. So for all of the other board members and everybody else still present right now, again, if you have anything specifically that you would like to ask Adam, now is your chance. Please feel free to send that through chat or to unmute yourself and ask away. Roll of silence. Speak now or forever hold your peace, I will say. But other than that, guys, thank you all so much for attending. I greatly appreciate your continued efforts for your community that you're serving and being a board member. We know it's not an easy task, and it takes a lot out of you, especially because you are volunteers. It's something that we understand you're not getting paid for. So by you being here today, we understand that you have the best interest of community at heart and want to genuinely do the right thing. So if there's any questions following this, please feel free to reach out to us. Let us know. Happy to answer those questions. I will definitely get with Mitch and go ahead and send a copy of the slide deck and the recording out to all of those in attendance today. And then Adam, again, thank you, sir, for your time as always. As wonderful. I really appreciate you taking some time out of your busy day to speak and to give out some great content.
Oh, thanks so much, Cameron. I appreciate you guys having me and listening to a lawyer drone on for an hour. But thanks for everybody for being here and for everything you do for your community. And I hope to hear from all of you very soon.
Awesome. Thank you so much. Hope everybody has a great rest of your day. And we'll go ahead and start ending the meeting.
Thanks, Cameron. See ya.
Take care.